Welcome back to our afternoon session of this year's Privacy Conference. We will start with, well, it's basically kind of a tradition now, a keynote delivered by the one and only Peter Fleischer. He's Google's Global Privacy Counsel, a position he's been in since 2006, so he's Google's longest-serving privacy leader. Peter counsels Google teams on how to design privacy-sensitive and legally compliant products, and he has met officials and leaders surrounding the data protection environment and ecosystem worldwide. So I'm absolutely sure he has some interesting things to say about us, for us on global data transfers, because that's the topic of our session. The session will be split into two parts. So Peter will be giving his keynotes, and then we'll resume with a panel discussion. Peter, for now, the floor is yours.
Thank you, Rebecca. It's very kind of you. I guess it's been 10 years that I've been joining the Bitkom events, usually in the Kalkscheune. So this time, for the first time, I'm joining you from my apartment in Paris. And I'm not going to give a speech as though I was standing behind a lectern, because I'm not. I'm going to be speaking to you as though I were speaking to you in my living room, because I am. And Rebecca introduced me as Peter Fleischer, which is how we Americans say it. But my mom would have meant it to be Peter Fleischer, and I would hope Rebecca will remember that next time. So let me say a few words about international data transfers. I've been in this field for, 15 years for Google and 10 years before that for Microsoft, so a quarter of a century. And why do I say that? It's because it's now been a quarter of a century that we have been talking about the data protection issues of international data transfers. And whenever you've been talking about and debating a topic in the field of data protection for that long, and I'm not exaggerating, literally for a quarter of a century, you know that there are no simple answers. If there were simple answers, this issue would have been solved a long time ago. So what is it about? Well, the way I think about it is there are kind of three aspects to this. The first is the technical, the second is the political, and the third is the legal. And different people on this call may be focused on one or more of those aspects. But let me just take a few minutes to share my thoughts. And again, these are just personal thoughts on these three different aspects of this problem. The problem has new life, of course, because of the recent decision from the European Court of Justice. But this recent decision of the European Court of Justice is just the continuation of a debate that has been going on for a long time, both in the courts and beyond. Well, first, a little technical reminders for myself and for others. We're talking about, in many cases, the internet here. And as I think all of you know, one of the pieces of brilliant innovations of the internet was a design of a network to move data packets around from point A to point B according to no predetermined path, but just to get them there in a way that they could move around any obstacles that might present themselves. And you could say in an original context, going back historically, that almost sounds like a military thing, and indeed it was. But the brilliance of it is that there's no way of knowing in advance when data is transferred from point A to point B, what path it takes. Secondly, from a technical point of view, you can ask yourself, does data even have a location? I mean, a document in paper format has a location. It sits on a desk or in a file cabinet, you know where it is. If it's mailed from point A to point B, you know where it is. It has a location. Things that have a location, like a car driving a street, are easy to identify and to say, okay, well, since I know where the thing is, I know which law to apply to it. But data in the digital format isn't really like that. It's kind of different. I mean, it exists within a physical infrastructure, say a data center, but even there, it's immaterial. It may exist in multiple places, it usually does, more than one place. It can be transferred, it can be copied infinitely with no degradation. It can be moved instantaneously at no cost. And usually the reality is that these things do not exist in just one location or one place at one point in time, but really have multiple, if you will, existences. So to some extent, the location of data is itself almost a little bit of a fiction that we're inventing to try to solve a problem that will come up in the next part, which is the political. So what is it about the political debate here? I mean, the political debate has been going on for a quarter of a century. And I think it's a very sensible one. It starts from the premise of saying, within a country, say Germany, or a region, Europe, we are going to define a set of privacy laws and principles. And those are going to reflect our democratic decisions and our values. And we want to make sure that our personal data continues to remain protected according to those standards, those laws, those values, regardless of location. We don't want those levels of protections to be undermined because data is transferred from point A to point B. You could call that data sovereignty, if you will. You could call it just a decision to make sure that the privacy laws continue to protect personal data, regardless of this thing called transfers of data. Well, that's a political decision, but there's another political decision, which is the political decision about how to balance government surveillance and privacy. I mean, every government, every region has to balance those two facts, and those are political decisions. On the one hand, governments have an obligation to protect their citizens. As you could say, it's one of the fundamental obligations of government, whether we're talking about the police or anti-terrorism or anti-corruption or anti-financial crimes, whatever you're talking about, there will be a set of rules about what a particular government can do with regards to government surveillance of personal data. And that will be balanced against the rights of individual citizens for privacy. Within a particular country, you'll have that balance struck in a particular way. There's not a right or a wrong answer here. It's a balance between two big competing interests, if you will. And even within Europe, we're seeing the balance struck differently. It is not struck today the same in Germany as it is in, say, Great Britain. And it's also not struck the same way in other countries, whether it's the United States or Japan or Israel, whatever you want to talk about. So when we come to this topic of international data transfers, and this is very relevant to the most recent set of debates on this topic, you have to ask, well, if a data is transferred, personal data is transferred from Europe to the United States, and the United States has made a political decision to strike the balance differently between government surveillance and privacy, does it undermine the rights that we have in Europe to privacy as defined by us in Europe? Well, that is a political debate. That's not a debate that company lawyers or data protection officers can solve. That's a political debate. So if the frameworks that exist as a political negotiation in this space are now put under new scrutiny, then at the end of the day, it's only the political authorities that can engage in this debate to solve them. So when I say solve them, what do we mean? Well, if we mean that Privacy Shield is no longer viewed as adequate, then it's up for the political authorities to discuss what improvements need to be made to the Privacy Shield. Let's call it a Privacy Shield 2.0 to meet the expectations of Europe's top court with regards to transfers from Europe to the United States. If it is additional safeguards that are meant to be applied by companies, well, what exactly do those additional safeguards need to look like? If it is something else, what is it? Are we talking about international conventions, like a United Nations conventions on data protection? Maybe. I mean, that's been something that people have been talking about for quite a long time. Maybe it's that. Which leads me to the third piece, which is the legal piece. Well, we have a decision of Europe's top court, and that's the law of the land now. And many of us on this call are data protection officers or lawyers and others who say, okay, well, we understand everything that Peter was just saying about the technical aspects and the political conundrums, but we still are lawyers and we still have to come up with some kind of compliance regime. It's our job to figure out how to comply with the laws, even if we find them confusing and contradictory, we may not agree with them, whatever. It's our job to use the instruments that we have to comply. And I would say those instruments are multiple. As you all know, under the GDPR, There are multiple legal bases for processing data, and international data transfer is one form of processing. So when somebody is looking at an international data transfer, I think people can look at the different legal bases under the GDPR to legitimate that transfer and decide which one might be appropriate in a particular context for a particular transfer. I mean, you all know what they are. They're not novel and they're not unique to the area of international data transfers. They apply to all forms of processing. They could be, for example, the consent of the data subject. They could be the legitimate interest of the data controller, in this case, the data exporter. They could be the necessity for the performance of a contract, and so on. And I'm not saying in advance which one might be appropriate, but they can be looked at. Now, some of you will have known from following the press and following the subsequent actions to the European Court of Justice's decisions back in the Irish High Court, that there are now questions about the use, for example, of standard contractual clauses. Standard contractual clauses, as you all know, are one of the mechanisms that was essentially negotiated by the European Commission to have a safe harbor, and I know I'm using a funny word because that came from a different context, to legitimate data transfers. And Europe's top court didn't say standard contractual clauses are illegal or don't work anymore. It didn't say anything like that. It said they need to be looked at on a case-by-case basis to figure out whether a data exporter could continue to use them in a way that would respect the requirements of the law. Well, that means it had to be sent back to the court, in this case, the Irish High Court, for an assessment of whether or not, in this particular case, Facebook, because it was a Facebook case in front of Europe's top court, could rely on standard contractual clauses for these transfers. And some of the advocates have been saying, well, no, of course you can't, because look, if Privacy Shield was struck down, then by analogy, standard contractual clauses should be struck down because it all sounds like the same thing. But that's not what the court said. I mean, what the court said is it has to be assessed on a case-by-case basis. And when I say case-by-case basis, we mean more than one thing. We mean, A, with regards to transfers to which country. I mean, the answer could be very different if you're talking about a transfer to, again, the United States versus Israel versus Japan versus South Korea, who knows, just add the list. It could all be different answers. And second, it could be different with regards to which category of data, which type of data, for which purpose, according to which safeguards. Those are case-by-case decisions. So there are a number of people out there who have been arguing that, well, gee, the entire framework of standard contractual clauses and other mechanisms for the international transfers of data has now been struck down by Europe's top court. That's not true. That isn't at all what it is. What they said is they raised serious doubts about the ability of controllers, data exporters, if you will, to comply with their legal obligations in Europe with regards to international data transfers, in particular to the United States, in light of US government data surveillance. But that is not striking it down fully. That is saying, look at it case by case, and we'll see what the answers are. So that's exactly what's going on now in the High Court in Ireland. It's looking at that particular case in that particular context. You know, I note again that, and I have nothing to do and have no particular insights into the lawyers representing Facebook there, but they made the somewhat hyperbolic arguments that have been reported in the press that, oh, well, if, you know, then if things go a certain way, blah, blah, they'll have to shut down the entire internet services in Europe. Well, look, you know, I'm not a fan of making hyperbolic legal arguments in front of courts. I don't believe in making these kind of exaggerated claims that the world comes to a stop. I don't think it does. And I don't think that's what Europe's top court said or meant. I think they were raising serious concerns that need to be discussed seriously. These issues, by the way, and again, I'm coming back to a 25-year history, have been with us for a quarter of a century. The world never stopped. These issues are not so dramatically different than they were a quarter of a century ago. They're kind of the same thing. And they're still legitimate. And there's no obvious solution. There's no obvious solution because they are political compromises between competing goals. And they're political compromises that are made differently in different regions of the world. Let me just say just a thought or two about what this means for sovereignty. Because at the end of the day, I actually think a lot of this is about questions of digital sovereignty. That's a phrase that's being used a lot these days. And what do we mean? It's the power of a particular country or region, Europe, to make its own rules, to say, this is what we expect, these are our values, this is our democratic system, this is what we want to be respected. And we want to make sure that those values are respected, in this global environment with this thing called the internet that has broken down borders in lots of different ways. And how do we ensure that our laws and our values continue to be respected in this world in the interest of digital sovereignty? And let me just take just a minute to talk about another decision of Europe's top court, the same court that issued this recent decision on international data transfers. And that was the Google Costeja case, the Google Spain Costeja case that instituted the right to be forgotten. That was decided about 5 years ago by the same court. And why am I mentioning that now? It's because Europe's top court created, if you will, read into the existing laws, a so-called right to be forgotten that exists in Europe that does not exist in most other countries in the world, almost no other countries in the world. And this decision was revisited by the court a year ago when the French data protection authority, the CNIL, said that a right to be forgotten delisting would need to be done worldwide, globally, in order to be effective. And we, Google, were arguing, well, no, it should be done in Europe to comply with European law, but not in other places like Japan, the United States, and so on, where that is not the law. In other words, we said we need to come up with a model where we can respect different decisions in different countries, to respect, if you will, the digital sovereignty of different countries in different places to make their own decisions. And at the end of the day, and this was almost exactly a year ago, Europe's top court, the same court that ruled on this international data transfers issue, agreed with us and said, yep, the right to be forgotten should be implemented in Europe according to our standards and our values, but should not be imposed on third countries around the world that have balanced tests that are different, that have constitutions that have reached a different result. That would be an extraterritorial application. That's not right. Now, why do I mention that here? It's because Europe's top court, in that case, created a privacy right, the right to be forgotten, that was unique to Europe and different than the rest of the world. And we at Google and other companies in the space complied with it in Europe, but not outside of Europe. I mean, to me, that's a really good model of how to respect the digital sovereignty of the decisions of a court, but not to impose this decision on the rest of the world, where the balance test on factors will be different. And the final observation I would make about this case, and again, it's because it's from the same court, is they did not base that decision on the location of data. They never said, we're going to base the decision about the right to be forgotten and where it's imposed based on the location of the data. And what do we even mean by the location of the data? What, the location of an article that's in BBC archives, the location of data that's in a New York Times archive? They never said that. They basically said it's based on the location of the data subject, the person who's searching for data, not where that person's data is located, which data center it might be sitting on. It's where's that person located. That makes a lot of sense. And that's how we have implemented at Google. That's what this court has now reaffirmed. And I think that could be a really interesting model for us going forward, thinking about this topic of international data transfers, focusing not so much on the abstraction of data and whether it has a location and where that location is, but rather going back to what really matters, which is who's the human being behind it. And what does that human being expect? And what are the rules that should apply and protect that human being? So this has just been a chat from my living room to you, as though you were sitting on a couch in my living room. And maybe some of us will have the chance to do that again. Stop here and rejoin in a few minutes in a panel conversation where we can then be interactive and engage in conversation with any of you who'd like to. Thank you.
Thank you, Peter, for this introduction, this keynote for our panel discussion. We're still waiting, I think, for participants to join. So we'll have a short break of about, I guess, a minute, and then I'll see you back here.
Thank you. Bye-bye.
All right, then. Welcome back. Peter is now joined by two more privacy professionals for our upcoming panel on global data flows. We simply cannot talk about international data transfers without talking about Brexit, unfortunately. So I'm very glad that Paul Gaskell is joining us again this year. Paul is the Deputy Director and he covers EU data adequacy at the UK Department for Digital Culture, Media and Sport. So welcome, Paul. I'm very glad you're here with us. Also joining is Bojana Bellamy. Bojana is the President of the Center for Information Policy Leadership, short CIPL. I guess you all know CIPL, and it's a global information policy think tank, basically, located in Washington, DC, London, and Brussels. Bojana, welcome. I'm very glad you could join us today as well. I'm just trying to calculate how many years of data protection experience we all have combined. I guess it sums up to more than 70 or 80 years if I throw in my own 10 years. So maybe we can solve this great puzzle of global data flows together in the upcoming 30 minutes we do have. So to get us all started on the topic, it's quite broad actually, but we do need to find solutions. But to get us all started, I would all ask you to take 2 minutes for a short introductory remark and give us your perspective on what the greatest benefit of a data economy based on functioning global data flows could be and what the main benefits would be for our society. Bojana, shall we start with you?
Wow. Okay, all that in 2 minutes.
Yes.
Well, look, I think there are clear economic benefits. And if you look at every single survey from McKinsey to the European Center for International Policy and Economy, every data shows that it is absolutely essential for economic growth that we do have as free as possible unrestricted data flows, but I would say and responsible, where privacy flows with those data flows and with data. McKinsey says that in fact, digital trade surpass the trade in goods and services. So it's the data that is actually driving that economic growth and GDP growth as well. It actually helps not just multinational companies for which, for example, Peter works and so many of you, but actually helps startups and SMEs because they can reach these audiences, they can be more efficient. Do you know that 80% of startups are actually born global? And I think that's so important to understand for Europe as well, where we do have this plethora of SMEs, small and medium-sized companies who are trying to reach new customers, be part of the global supply chain. They're using global technology as well. So for them, it's essential to be able to participate in global data flows and digital economy and digital trade. But very importantly, it's important for us as people. We are now literally living, working, interacting, socializing, praying online, right? We as people have got huge benefits as consumers and citizens of being able to connect with others. Our democracy is better for it. Our own horizons are being expanded. Our access to education, to healthcare, to friends and family, to new thoughts. So I'm a huge proponent, of actually not just global data flows, but actually globalization as well. So I do worry in this post-COVID world when I see calls for nation states and also in the digital world, when I see barriers to data flows, and Peter talked about digital sovereignty as well, I really worry about that because I don't think that's what this world is about. We have to go back to get rid of that digital sovereignty and this populism, but go back to ensuring everybody has a piece of that global cake.
Ensuring a piece of the global cake, I'll remember that. Paul, what's your take on the issue? What's the greatest benefit you see?
So Rebecca, thank you. I was pleased to get this question because it actually gives me an opportunity to plug the UK's new national data strategy, which we launched on the 9th of September. And there's a consultation ongoing, and we'd be very keen to get views by the 2nd of December. So I'm happy to share a link with participants if that's of interest. But our national data strategy very much focuses on the benefits of the global data economy and global data flows. It sets the UK an ambition. It's an ambitious pro-growth strategy for all data, for personal data, but also non-personal machine data. And it sets out some key areas where the data economy is of benefit to the UK and globally. The first one is about boosting productivity and trade. So we will be continuing to champion the free flow of data globally to boost UK and global growth. But crucially, a regime that builds public trust and is based on high data protection standards. And I think we need to be very careful. There isn't a zero-sum game. You can have free trade, free flow of data underpinned by high data protection standards, which is necessary to ensure we have public consent and public trust. Data economy also builds new businesses and jobs, and that's going to be even more important in the post-COVID environment that we face. And I think it's been remarkable, actually, while COVID has been a tragedy, in economic terms, we have seen businesses, government shift almost instantaneously from working in offices to working from homes. Here we are doing that now. So there's a huge amount of flexibility and opportunity there. The data economy increases the speed, efficiency, and scope of scientific research. Again, we have seen that with COVID as well. It's helped governments manage this global emergency, but also helping scientists collaborate worldwide. And finally, my last thoughts, data economy also helps deliver better policy and better public service delivery. A greater supply, a more effective use of data can help governments deliver services more efficiently, more economically, and better.
Okay, thank you. And Peter, your 2-minute chance to pick up on where you left off.
Yeah, well, of course, I agree with everything Bojana and Paul said, but I would even make it a little bit more basic than that. You know, I think what we're talking about here is the development and the evolution of very fundamental trends. And these very fundamental trends are technology, knowledge, connection. I mean, the most basic things in the world. And they will continue to advance. But I'm not a utopian. They will advance for good if we're all smart enough to use them for good. And we're all smart enough to try to avoid the pitfalls that they will present. But these trends, you know, they're tectonic. They will happen. They will happen regardless of what we do. These things are in motion. And it's up to us, and it's up to the people who are concerned about these issues to try to make sure that this evolution of science, this evolution of technology, this evolution of knowledge and connectivity continue to be really good. Like I'm an optimist. I think this is how the human species progresses, and it always has and always will. I mean, short of being thrown back into a new stone age. But you know, the idea that science will not continue to progress and will not continue to throw up all sorts of challenges is something that has never not been true in the history of the human species, and it's just accelerating. So, you know, I think we have a lot of runway to make really good use of this, as Paul was saying, as Bojana were saying. But you know, the only change, if there's a change from the way this has always happened in the past, is it will happen faster in the future.
So what I take from all of your introductory remarks is basically that we do want and we do need global data flows to work. But given the recent judgment of the CJU and the current situation with Brexit, it all became kind of shaky. And I hope that we can dive deeper into some of those issues just now. So maybe, Paul, let's start with a Brexit dimension. What are the implications of Brexit for global data flows, especially given the importance those data flows have for the UK economy?
Thanks, Rebecca. So for the UK, obviously, we have now our own independent data policy. And as I mentioned with our new national data strategy, it is the UK's ambition to remain and become even more a centre of the global data economy and data innovation as well. Our future regime is still developing, but there are some fundamentals that are already very, very clear. First of all, the UK will continue to have a global outlook. We will continue to champion the free flow of data internationally with all the proper safeguards, of course. Will be, and as well as promoting as well as having a robust domestic regime in the UK, we'll continue to work with international partners to ensure that data is not constrained inappropriately by national borders or by fragmented regulatory regimes. So that's our global approach. I think it's important, though, to repeat again that we remain committed to maintaining high data protection standards for personal data. We have left the European Union with the same legal framework as the European Union, so the General Data Protection Regulation and the Law Enforcement Directive for law enforcement data. We are seeking 2 adequacy decisions from the European Commission. Those discussions are ongoing at the moment. And there will be no race to the bottom in terms of UK data protection standards. And then extra element as well, it'd be really important that we ensure that regulators are properly joined up and continue to cooperate too. We will also be establishing our own UK international transfers regime. We have inherited the legal framework from the European Union. And so this will allow the UK in due course to assess and designate third countries and territories as adequate for UK adequacy decisions going forward in future. But what we've said in the meantime is that we will continue to allow personal data to flow from the UK to the European Economic Area and to adequate third countries with whom the EU already has adequacy decisions for the foreseeable future in the interim as well. And then the final point I would say is that how in our work to establish new free trade agreements with partners globally, within those free trade agreements, data will be an important element. And as I flagged, provisions, for example, to restrict as far as possible data localization will be very important to us. But we will keep data protection separately, quite rightly, in separate data protection regimes to make sure that there isn't a trade-off between trade versus data protection. But as I said, we do not see a tension. We think it's perfectly possible to have free trade and free flow of data and the highest standards of data protection. So that's the overall outlook, but I'm happy to answer any particular questions on specifics.
So just a quick follow-up question. Your data strategy will enable data to flow freely between the UK and the EU and will enable businesses to work together, basically, after the end of the transition period.
Yeah, the national data strategy, that's slightly separate from the national data strategy, but it is true. We have said that we will continue to allow data to flow freely from the UK to the European Economic Area and countries with whom the EU already has adequacy decisions. That will continue, although we'll keep that under review until we establish our own international transfers regime. Of course, for data flows from the European Economic Area to the United Kingdom, that is subject to our discussions on data adequacy with the European Commission at the moment.
Thank you. So, Peter, for a global company such as Google, how did you prepare for the end of the Brexit transition period, and how will you continue to secure data to flow globally as freely as possible, considering that the transition period is ending and also considering the Schrems II ruling?
Well, it's a panoply of approaches. I mean, you can look at it from a purely legal point of view, or you can look at it from a technical point of view. From a legal point of view, we're relying on multiple legal instruments, standard contractual clauses when they're appropriate. We'll rely on consent when that's appropriate. We'll rely on international frameworks like adequacy or Privacy Shield, or maybe someday Privacy Shield 2.0, but that's all from a legal point of view. From a technical point of view, in some ways that's probably the more important one. The challenge here is to build a system that protects user data And at the end of the day, that's really about protecting user data in a way that people expect, meeting their expectations of trust. And that doesn't change based on geographies or based on political shifts in the winds. That really is pretty fundamental stuff. And we try to make that as local as possible. So it's not like from a fundamental data protection point of view, there's any change pre or post Brexit with the data of Brits compared to the data of, say, French or Germans, to build a global system that is reliable, that respects the privacy of the people involved. And, you know, there will be shifts along the way. But again, I'm not a believer that the world changes in terms of the participation of Google in the United Kingdom or Brits in the global economy overnight based on whatever the political decision is to join or to leave the EU. And the same is true with regards to whether the United States is viewed as an adequate or not an adequate country under the Privacy Shield, and so on. So it's a much bigger issue where we're trying to build a global, respectful data protection regime for user data everywhere.
So even in times of crisis and uncertainty, you do see a way to move forward. That's kind of good to hear, I have to admit. Bojana, considering also what Peter just said, and also considering the whole Brexit situation we are in, as you're spearheading Supple's work to develop global solutions for responsible data flows and global privacy, what steps would you recommend companies should be taking right now to ensure their data flows to secure their future, basically, in the global economy?
Rebecca, I have to be the optimist like Peter, but I do have to say that I personally, just like Peter and many of you, have been working on privacy and data flows for over 25 years. And this was my first, and my first task was to devise a privacy strategy for a company in respect of data flows. And I kind of I am optimist. I think we will find a solution, but, you know, I worry when 25 years later, we are still, debating these things. But anyway, in the optimistic nature of this discussion, I think there are solutions out there. So first of all, I think both regulators, policymakers, and companies have to work together. I don't think we can solve this quite all on our own. What do I mean by that? Companies are really between rock and a hard place. They are dealing with two conflicts of law situation, a conflict of law of sort of national security and surveillance versus privacy. And it is similar to, the one on right to be forgotten and freedom of expression versus privacy. It is also similar, I will remind those of you who are practicing about the business ethics line and Sarbanes-Oxley requiring company to report unethical or breaches of internal policies. And that was also a breach of, was a conflict with European privacy regime. So, we did find solutions for all of these things. And so we have to find solutions, but we have to work together. And I really am worried when I see data protection regulators having this bunker mentality at the moment, and each of them coming up with their own responses and even some with published guidance, as opposed to working consistently in the EU to create a legal certainty for all data transfers and single interpretation of this difficult court decision. And I also would like them to open up really to industry as well, and not just send their have almost baked guidance for consultation when it's all ready, but open those channels of communication beforehand. Of course, we want to see governments debating these issues as well, and not just at data protection regulatory level, but at global level, political level, because it is a political issue ultimately. I agree with that consideration. And in terms of Privacy Shield 2.0, it really is for the EU and US to try to create a mechanism that actually would be sustainable and perhaps be able to be defended against another onslaught in the future. And that's not impossible. There's some very good ideas coming from the other side of Atlantic as to how that may be done. But this isn't just about the US. This is where I really worry a little bit about the discussions on Schrems. Data is flowing truly globally, and it's not in the US. It's actually, as Peter said, it's sharded data. It's the fragments are everywhere. And in that respect, I actually very much look forward to the UK's role, because I think, Paul, without pressure, I think UK can play this bridging role in the future, right? It is possible to be innovative, to come up with solutions, but also retain high level of privacy protection, get adequacy from EU. That has to be the priority for UK, and obviously mutual adequacy, but also experiment and take the GDPR further as well, because we haven't done that in EU somewhat. There are data mechanism, transfer mechanisms that we can develop further, like certifications and bridging with other certifications as well. So I'd like us to be a bit more creative and a bit more courageous. But I really do appreciate that Schrems' decision has made everybody more conservative. Data protection authorities will be more conservative. Companies might be so as well. Those of us who are thinking aloud, but anyway, I think we mustn't do that. We have to actually try to get out of this mess. We at CIPL have actually just issued a paper on the path forward post Schrems. Here it is. I can show it to you. It does exist, but of course it's virtually available on our website, where we are looking at some of the practical solutions, short and medium term, to overcome, in the sense of what can companies do? And of course, we look there at a number of other data transfer mechanisms that exist under the GDPR and what the impact could be on them. As we know, the court has not excluded them. They are valid, they remain valid, and the derogations remain valid as well. Of course, adequacy decisions will have to be relooked, but companies are not prioritizing for those countries. We also looked and asked companies who we work with to tell us about what they're doing in terms of doing these risk assessments and assessing on ad hoc case-by-case basis the laws of the third countries, as well as their risk and severity and likelihood of that governmental access to data, and what do these supplementary measures could look like. So we kind of write a lot about that, and we are seeing some really promising best practices out there that companies are putting in place, but this is not easy. And in some ways, the court has now outsourced the adequacy decisions to companies and the board, the DPAs, as opposed to the commission. So I think this is a big shift. And I'm not sure whether we want to stay there, whether the court might change its opinion, perhaps. But I don't think we should not be, we have to deal with it as it is, but we should not lose sight of actually where we have to be and where we could be as well. And then final point that our paper talks about is the accountability of organizations. And in fact, the judgment doesn't talk about risk-based approach nor the accountability, but it actually underpins everything. And so how would accountable organizations deal with governmental access to data? So we asked that question, and we've got lots of data points from leading businesses out there who are actually doing quite a lot to be accountable, to deal with the governmental access to data in the best possible way, to resist, to challenge, to limit the scope, to escalate. They've got teams. They even benchmark externally these things. So it isn't really kind of Wild West out there where, people are opening kimonos to governments. Yes, sometimes it happens. It has to happen legally, but it's important that we talk about what can be done and that regulators also understand what is happening on the ground as well. My final point of what we could do is we could think about this bridging solutions and not imposing one size fits all. I honestly hope that other countries are not going to copy Schrems II decision, in the sense that they will not require this high bar when they're regulating transfers from Brazil to elsewhere, from India to elsewhere, because this really would be the end of data flows and the end of internet. So we have to give some confidence to these other countries to say, you can be adequate without copying this high bar of Schrems' decision when it comes to your own data flows. And again, as I say, we have to look forward for those bridging opportunities. BCR to BCR, BCR to CBPR, certifications with CBPR. I always talked about this. I know that Commission is very worried to look into this, but maybe UK could do that, right? Other partners, those countries that can, let's look to do these sort of multilateral solutions as much as possible. And then hopefully Europe is going to be joining us, because European businesses want these solutions. It isn't about ideology anymore. It's about the need to ensure competitiveness of European businesses so they can compete out there on AI, on having the access to data, to training data, having the access to best skill sets as well, being able to move data to fit these global needs as well. So maybe I'll stop there, because otherwise we can go forever, but please do look at our paper. I hope it does have some really practical solutions for medium to short term, getting us out of Schrems.
We will. Maybe we can even post the link to the paper in our group chat later on.
Okay. Once I get to the quality.
Yeah. But Paul, Bojana really rolled the ball into your court when she said you could be the bridge. You could find a solution. But first of all, you have to find a solution for the Brexit and the end of the transition period. So let me first ask you, what measures have you already taken? What steps have been done already? And what can we expect from the last weeks of this year to come till the transition period ends?
Thanks, Rebecca. I will just pick up briefly on Bojana's comments about Schrems too. And I think, yes, I think it's a challenge that all governments are wrestling with. And of course, it's been factored into our discussions with the European Commission. We are confident, actually, if you look at the UK's legal framework in terms of the transparency, the safeguards, the oversight, that we are Schrems II compliant. But I think a lot of countries in the world may not be. And I think there is a fundamental point here, and I sort of referenced it with regard to trade earlier, that we should not see security and data privacy as always being in tension. Democratic governments can protect the security of their citizens, have national security frameworks, but also properly rightfully protect the privacy of personal data. So I think this zero-sum game, I think, is very unhelpful, and I think we need to look at that collectively as a global community. You asked about the end of the transition period. Well, of course, it depends what the outcome is. So if, as we would expect, we are successful in securing data adequacy, then there will be no change. The personal data can continue to flow from the UK to the EU and the EU to the UK as before, with no discernible impact for anybody involved. I think the risk, however, and there is a real set of risks, is if for whatever reason we are not successful in getting data adequacy. I think that would be, frankly, quite a strange state of affairs, given that we have left the European Union with the same legal framework and very high standards, but there we are. As I said already, in that kind of no adequacy scenario, we've already said the UK, we will continue to allow data to flow freely, personal data that is, from the UK to the European Economic Area. The issue, though, of course, is for data flows from the European Economic Area to the UK. And there, I think what's going to be very important is that all businesses and organizations in Europe that send personal data to the UK, they should be looking now at alternative transfer mechanisms such as standard contractual clauses or binding corporate rules. They should be talking to their United Kingdom partner and making sure that those legal mechanisms are in place in good time before the end of the transition period. There's a lot of guidance out there. The UK government has lots of guidance. Our Information Commissioner's Office does as well. And I believe there's some very good guidance as well from the European Data Protection Board and EU regulators. But I think it's really important that European partners who send personal data to the UK, that they act now. I'll stop there. Thank you.
Thanks. We're sadly already basically approaching the end of our panel, but I'd like to give you all the opportunity to look at the topic of global data flows in the context of our current situation, because the COVID pandemic has changed, our lives, like totally. We are working from home. Some of us have different roles to play at home as well, because schools were closed and kindergartens and stuff. So the world changed. But as I have you with me today, and you have so much experience under your belt, I would like to hear from you what you think global data flows can offer us. What benefits they could bring in times like these, basically, in a time of pandemic where we had to change our everyday lives, do nearly everything remotely, even this session today. Yeah, maybe Peter, shall we start with you?
Happy to. Well, it's funny. I mean, never in my entire life has there been a period where I personally, as a human being, don't get to travel anymore. So as I'm home, I'm glad my data can still travel the world and be part of a larger global data system. I think about, like, what can different players do to address the issues that we're talking about here. Companies can do some things. One of the things that Google is doing transparency reports, where we publish on a periodic basis, for example, how many requests we get for government access to data on a country-by-country basis around the world. In other words, that's contributing insights. It's information, it's transparency. And then others, policymakers and others, can then look at that and say, okay, well, that's what's going on. What do we need to address it? Then I look at different governments and how they've engaged. The Confidentiality Commission in the US very successfully talked about this issue in Privacy Shield 1. Why won't they do it in Privacy Shield 2.0 if that's what's required? I look at the Japanese model. When the Japanese were discussing adequacy with the EU within the context of a free trade agreement, they approached the question from a reciprocity point of view. It's sort of like, well, if European data is restricted from going to Japanese data, be restricted from going from Europe. And so if there is a reciprocal arrangement that meets the data protection requirements of both countries, regions, maybe that's the best way forward. So in other words, not think of it as a one-directional problem to be solved, but rather as a reciprocal framework to be solved. And again, we put all of this against, just the realities of the world, whereas increasing the ability of data flows is just fundamental to all of these big new trends that are going on in the world. And let's be clear, there will be winners and losers. There always are. And the winners and the losers will partly be defined by who adopts these trends most effectively for good, for building new businesses, for educating society, for fighting disease, and so on. So, it's very nice to engage in a precautionary principle, but precautionary principles that prevent people from latching on and innovating and driving new trends, at the end of the day, that's not really a formula for long-term success. So I'm an optimist, but it does mean, engaging in this debate, finding solutions and not throwing up their hands and saying, gee, everything has to stop. That's not going to work.
Bojana, your 2 cents on the issue.
Well, yes. I mean, look, I actually think this is right. I think we're going to see businesses moving, frankly, to those locations and those countries where they have got better conditions to actually conduct business and more legal certainty and more support in every sense. I honestly think that's what the globalization has actually enabled companies to do. That's what these startups are going to be doing, because they do depend, 80% of them depend on global data flows. So I think that has to be so informative for every single policymaker, every single government around the world. And these governments have to think like that and get together. I was hugely pleased to see that at G20, where in fact we as CIPL, we had a side event together with the Japanese Privacy Commissioner. At G20, this whole discussion of free flows of data with trust, right? This was former Prime Minister, now Abe. He's coined that phrase. That was a discussion at the highest level, G20. I want that to happen again, right? And together with the surveillance issues. So OECD has started looking into surveillance issues to sort of try to address, if possible, within the OECD guidelines, the governmental access to data, but also data localization. So, we need also governments and policymakers to kind of engage on this topic, and member states of the EU, as opposed to just the EU and just us companies trying to find the right way. My last words would be, and as we do that, we honestly have to fight with everything we have got against data localization and this data sovereignty demons that are growing around the world. And Schramm's decision is just going to, I fear, increase these kind of trends. So we have to explain the data. I think Peter has done it very well, but data localization does not help anything whatsoever, because there's no such thing as location of data. It doesn't work economically, it doesn't work legally, it doesn't work competitively. If you want to be competitor in AI, you need much more data, you need more access and movement of data and better quality data as well. So I worry when I hear these rhetoric coming even from parts of the Commission about EU digital data sovereignty. I don't think they mean it. And I think we have to absolutely stop talking like that. And globally as well, quash as much as possible any pressures for data localization. And companies should also resist market pressures for data localization, because there will be these market pressures as well. But again, trust me, it doesn't work legally, because you could still be reached long arm by the US or any other governmental authorities as long as there's shared systems available.
Thank you, Bojana. I think that is an excellent point, and it's very good. You made it say, like, yeah, firmly. Paul, I'll give the last words to you.
Thanks, Rebecca. I'll be very quick. And so just to agree, really, I think that the crisis and tragedy that is COVID-19, what it has done, I think, is speeded up trends that we have seen more widely that have been ongoing. I think that the data economy, data flows, data innovations are good things. They are good things for humanity, although, of course, they need to have all the proper safeguards and et cetera. But, again, I just think of the examples around the unprecedented global cooperation on research into COVID-19 would not have been possible without data flows. Similarly, I mentioned the sort of instantaneous transfer of the economy and government from office blocks to bedrooms, again, would not have been possible without the global data economy. So we can't hold it back. We need to work with it to the benefit of our citizens.
For the benefit of our citizens. I think these are wise and very good last words for this panel. I hope we can continue to work together to really solve the issue, because Bojana, you said it, we're talking about it like for ages now, 25 years, quarter of a century. And I really hope we won't be having the same discussion in 25 years again. If we do so, I will be very happy to have you again with me on a panel such as this to find a new solution. But I hope we'll be faster. Thanks for today. It was lovely having you, and I hope to speak to you soon.
Thank you. Thank you, Rebecca. Bye-bye, everybody.
Bye.
Great.